All right, guys, welcome to another episode of Hustle and Grit. Today's show, podcast, however you're watching this, is going to be a really good one. We're actually going over an agreement of purchase and sale, and all the responsibilities of a buyer and seller in a sale transaction or purchase transaction when you're buying, selling a home in the province of Ontario.
Very important. A very important episode because we often find that clients that come into Treadstone Law for their real estate closings, although this agreement is the same one that's used by basically everyone in Ontario, they really don't understand the agreement. They don't understand what they've signed and all the implications of it. So this is an opportunity for us to kind of go over each of the different clauses and help you guys understand what the agreement really means.
Yeah, and I think that a lot of people, when you're buying or selling, so when you're buying, you're so kind of caught up in trying to find that best house, or when you're selling, you're trying to, you're working hard to get a good offer, that you don't really think about the agreement of purchase and sale, which is kind of dictating the relationship with you and the buyer, and then what is your responsibility in it all and how to make sense of it all.
Yeah, no, for sure. And I think what makes it more of an oversight for people is that because there's a template used, people think that everyone is just using the same document, so it's probably okay. When in reality, that template is the foundation to build your agreement. You have other areas within that agreement, your conditions, the appendix to add to that agreement, and that can really change everything involved in both your responsibilities and the other party's responsibilities as well.
Yeah, and I've had buyers and sellers already sign off on an agreement, and then they'll tell me something that, like, obviously is not in the agreement, and I would say, like, what makes you think that, like, you can or can't do this, or the other person has this responsibility, and all of it is hearsay. So it's like, well, I thought it was this, or I thought it was that.
Yeah, like my neighbor told me that this was the case and something, and I think you have these kind of beliefs that kind of just form. Without really understanding what that actual clause or that kind of the implications of that particular area of the law are.
Yeah. And then what is even more kind of dangerous is that sometimes you'll have people who will read the agreement and they'll say, well, it says A, B, C here. But the thing is it's not just about reading it. In order to interpret it properly, you need to, like, really understand what the law is, right? So that's not just what's on the paper. It's like just case law. There's a lot of stuff behind it that gives it its meaning, okay? So just because somebody says you don't have any conditions on the property doesn't necessarily mean that there's no responsibilities, right, of a seller or a buyer. So, and reading it for face value, and I've had people and clients kind of say, hey, right here it says this is my right. That's not what it's saying, right? Because often enough, it's just you're reading it from your own perspective. Sometimes you're under a lot of pressure and you want it to read how like you want it to read, basically.
Yeah.
And so, yeah.
Oh, go ahead. Sorry.
And so it's incredibly important to understand it the way it should be understood.
Yeah, no, that's so true. Part of what I think needs to be understood is that you have this agreement, and there's a sentence in there that could be taken several different ways. What happens in our legal system is then you have the courts that kind of cases will fight it out. The two sides will argue over what that sentence means, and then the judge will decide this is what it means. And then that will happen again and again and again. And then over the years, you have these boundaries that are made where this sentence can mean these things. And if there's a case that said it cannot mean this thing, then you have to understand that as well. Right. So I think that's very important.
Yeah. And that's, well, I mean, you're not expected to understand all of that. That's why you're hiring real estate lawyers. Again, I think we forgot to talk about the sponsor of this
and,
show.
and who we are. And
So the sponsor of this show is Treadstone Law.
My name is Umar.
My name is Harris. We're both practicing real estate lawyers in Ontario. Our firm is based out of Mississauga, Toronto area, GTA, but we are servicing across Ontario. We are a digital law firm, so everything is done online. So whether you're in Thunder Bay, you're in Toronto or Ottawa, wherever you may be, Timmins, your closing is completely done online. So our offices have completely moved digitally. We do everything from the comfort of your own home. Anything else? Did I leave anything out?
That sounds good.
Yeah. And today's episode is good for both buyers and sellers. So we're going to be talking about, it's going to be a bit of a ping pong game. We're going to see what responsibilities buyers have, what responsibilities sellers have, because we play both sides. Sometimes our clients are sellers, sometimes our clients are buyers. So we know what the roles and responsibilities of every person is, and we can give you tips on perhaps how to go about this agreement of purchase sale the best way. So without further ado, let's jump into it. Now, I think I will provide a link to an agreement of purchase and sale below. So you can take a look at that. The agreement of purchase and sale that we're going to be going through is an OREA agreement of purchase and sale. So OREA is the Ontario Real Estate Association. I would say probably, and this is just out of experience, like 95% of closings are based off of this agreement.
Yeah. Probably even higher.
Yeah. So, I mean, and the reason, like, it's not like you have to use OREA. I would say that I think there's a lot of banks that would, smaller banks, I would say especially, would only want you to use OREA. You can draft your own agreement, but typically if you're using a realtor, you're going to be using OREA. Typically, for one reason or other, if you have a lawyer who's drafting your agreement of purchase sale, sometimes they'll use their own agreements. For the most part, they're also using OREA. So I know we use, if we have anything, we prefer OREA over anything else, just because all the parties understand what this agreement has, and that's why we would we would say that this is something that I would basically advise clients that's a good option to have. Not necessarily 100% of the time would this be your the best option for you, but for most part it may be. Now,
so the one that's going to be posted below is the residential OREA purchase form. But at the same time, there is that caveat that there are a few different versions of this form. There is this agreement. There's one for condos. There's one for commercial real estate as well. Yeah. So this is for a detached or a semi-detached home.
Yeah, but at the same time, if you have condos, it's not a huge difference.
Yeah,
okay, I'm not saying it's the same, but it's not a huge difference.
I guess we can drop all of them below.
Yeah,
didn't realize.
Yeah, so we'll drop all of them below, but there's not a huge difference in terms of what it is. Okay, so first page of this OREA form. This OREA form 100. You start off with something that's fairly familiar with everyone. It makes sense. You go off and name your buyers and your sellers, the address of the property, the legal description, your purchase price, and your deposit.
I think most buyers and sellers, those few clauses are where their main focus is, in addition to the closing date. What's the purchase price? Which house is it? And what's the deposit? When is it closing? Yeah. And they kind of skip through everything else because it's seen as something standard. So we will be focusing on the other categories, the other clauses that are kind of not looked into as much.
Okay. And we're not covering this in a granular level. We're looking at 90% of the questions we have because we only have 45 minutes, an hour to go through all of this. We could be here for like the next week if we're talking about every single scenario that can kind of come up. So we're talking about the issues that affect the vast majority of people using this agreement.
Yeah, a lot of the questions we get, sometimes when issues arise, these clauses are relevant. By issues, I mean when it's something that a buyer or seller did not understand before they signed, and then they came to our office, and then something happens, and all of a sudden it's not what they expected. And these particular clauses are involved in those kind of scenarios. So that's why it's important for you to understand them, at least at a high level.
Yeah. Yeah. So anyways, back to this purchase price. And then we have a deposit. Deposits typically handed over to the seller or the seller's representative. So either the seller's lawyer or the seller's real estate agent. We would never advise a buyer to submit the deposit directly to the seller. It should always be held in a trust account, either a law firm's trust account or a realtor's trust account. It's typically handed over 24 hours after the acceptance of this agreement. So the acceptance of this agreement means that both sides have agreed to this agreement. It's not being negotiated, and then you're like, okay, here you go. Okay, so just because somebody is still talking about it, if the buyer and seller are still negotiating, you don't have to put up the deposit until it's been accepted.
So I have two questions for you.
Yeah.
So why is it important to provide the deposit to?
I mean, the reason you want it in a trust account is because trust accounts are insured. There's one thing. Second thing is it's not only the trust accounts are insured, there's professional liability and all of that. So you do not want to give it to the seller. If the seller runs off, it's just to protect the buyer, to make sure that the seller's not going to run off with the deposit.
Okay. And what about that time frame? You mentioned 24 hours.
So
why is it important to have that deposit?
So if it's
received?
so if it's not received in 24 hours, it's a breach of the agreement, which means that the buyer, or sorry, the seller can back out of the agreement if they choose. If it's a big enough breach, they can back out, and they could say, listen, you didn't fulfill this part of the agreement, and I'm going to find somebody else. This is more, I think, important, especially when you have like a strong market and there's bidding wars. So if you don't put in your deposit right away and they find somebody else, they could probably back off and say, okay, we're selling it to the next person.
And as a seller, it's kind of it is your security. So it's important for you to have that deposit as quickly as possible. And if you don't have it, then there is that risk that you don't have this security, and you have this person that's kind of promising to sign it with this or buy it with this agreement, but they haven't really taken a step towards buying it. So maybe it is actually better for you to start considering that other offer if that buyer does not give you their deposit as quickly as possible.
Yeah. So, if they're serious, they would put that deposit down, definitely. So the next section is the irrevocability. Now I've got a few things around this because this is one of the more contentious sides I've seen, at least in the beginning of this, like just agreement formation. So typically, what ends up happening is the buyer's side typically drafts an agreement and says, puts in their stuff. I want to buy this house for this price, this down. These are my conditions. Okay, and then they give it to the seller or the seller's representative. Representative as in realtor or lawyer again, and they say you have until 5 o'clock tomorrow to accept this agreement and send it back. If you don't, it's automatically nulled. So nulled means basically if you don't accept it during that time period, right, you can't accept it afterwards. The buyer is not going to be bound to it. So if it says 5 p.m. and you accept it 5:01, the buyer does not have to accept it. Now they can come back and say, you know what, I don't want to do this anymore. Maybe I want a lower price. Maybe I want a lower deposit. Maybe I want some other conditions on there. Whatever it is, they don't have to accept it. But if you do it within that time, right, you're definitely, then the buyer has to kind of they're obligated. Now, where does the biggest question come from? I have countless sellers that come to me and they will say, hey, or even buyers, but mostly sellers. So I have a buyer who's put in an offer. They say it expires tomorrow at 5 p.m. Okay. And I need to get this signed and sent back. And my first question is, do you agree with the agreement of purchase and sale? Do you agree with all the terms? And they will say, well, no, I want a higher price. I want this, I want that. And basically what they're explaining to me is a counter offer. So when you have a counter offer, which means that you don't agree to what the buyer is is saying you want to give them an offer and say, okay, well, they said they want to buy it for $500,000. I'm only selling it for $1 million, right? So you're going to sign back and you're going to say, no, I want to change it to $1 million. Even though often enough people are using the same document, it is a new agreement. So that means that you're saying no to the offer that the buyer's put in front of you, and then you're creating a new agreement. That means that the irrevocability time no longer matters. So you don't have to respond by 5 tomorrow. You only respond by that time and day if you are accepting the agreement as is. If you accept everything, then you have to put it in by that time. If you don't, then you don't have that deadline. I'm not saying to take your sweet time, but that deadline doesn't really exist because you're going to give them a new agreement.
That is important because another perspective on that is you should consider that the buyer is waiting as well. So you don't want the buyer to start shopping around somewhere else. So maybe the buyer gives you an offer that expires the next day, and you're taking some time, you're thinking about it. You take 2 to 3 days to provide a counter offer. That makes sense in a lot of circumstances. But if you're taking a week, 2 weeks, then now you're that buyer might be in a territory where you've left their irrevocability date, you've ignored it, and now they've moved on maybe and started looking somewhere else. So consider the timing. Just the difference is that if you don't want to accept the agreement as is, that is not a deadline for you. But at the same time, be strategic when you're making those decisions. And if you have the right realtor, they'll probably be guiding you through that process and telling you how we should approach it and how to negotiate.
Yeah, so your realtor should be guiding you through that entire process. But you should know for yourself as well. So when you have something that says, hey, this is expiring in 3 hours, but you don't like the purchase price, no need to panic if you can't get a hold of somebody, because you're going to be giving them a new offer. Now, number 2 is the completion date. So completion date is the date of your closing. And it will it's always on this agreement, 6 p.m. So by 6 p.m., you agree that the buyer is going to provide the funds to the seller, and the seller is going to provide vacancy in the unit to the buyer. And so you have until 6. Again, this normally comes up when we have a lot of sellers who sometimes last day are like, oh my God, I still have stuff in there. When do I have to move everything out by? I never suggest you wait till the last minute. I always will suggest that you should move everything out the day before. But if you don't, then you have until 6 p.m. the day of the closing to move everything out.
The caveat is the title transfer offices close at 5 p.m.
Yeah.
And also some banks might also have that issue as well. They close a little bit earlier. So you need to make sure that if you want to actually close everything and be able to have access to your funds, get everything moved out, and give enough time for the lawyers to transfer title before 5 p.m.
Yeah.
Because otherwise then you'll be closing in escrow, which means that you might not have access to funds until the next day when title is transferred on the next day.
Yeah. So the other thing is when people individuals are buying and selling, they tend to say, okay, we're going to buy and sell the same day. That gets difficult. So if you are somebody, and I would never advise this, and I'll explain this why right now. If you're selling a property and you're using those funds to buy a property, if your buyers of the property that you're selling provide you the funds at 5 p.m., all right, they're not in breach, and that transaction is closed, okay? But 5 p.m. does not allow any time for us as a law firm, for example, to forward those funds to your sellers, to the property that you're buying, in order to close on the same day. And because you can't do that, now you're in breach. So we always suggest that the best thing to do is sell one day and then buy the next day. A lot of people say, no, well, I don't want to spend more money on a hotel. I don't want to spend money on a U-Haul truck that for an extra day, whatever it may be. The fees for going into breach are going to be much higher than any of those and more stressful. So it's not, trying to save a few $100s. It's not the wisest decision. So where this much money is on the line, I would definitely think about getting a hotel and buying the next day.
And when there's a breach, the total cost of that breach is not predictable as well. It's generally high. You have the legal fees. You have the other side charging penalties, other side charging their lawyer costs, a lot going on. But if you have a buyer that incurred a lot more damages for that 1 day delay, then now they'll be asking for those damages from you as well. So it's not really something that you want to be in a position to have where you have an unlimited amount of damages possibly for that delay.
Yeah. So that's one of the biggest things, and that's why we always advise that it's not stressful for you, and there's just less on the line. Next, we're going to, and we're not going to be covering every single clause here. I think we're just going to cover the most important ones. You want to jump to shadows and fixtures. We'll throw that in as one.
So that's clause 4 and 5 in the agreement of purchase and sale.
Clause 4 and 5. So shadows and fixtures. Now it says shadows included, fixtures excluded. So fixtures is anything that's attached to the property. Okay, anything that's attached to the property is automatically included in the house. So if
there's one caveat there too, where you have case law that defines certain things as fixtures that maybe weren't fixtures. There's conflicting case law too sometimes, like what is it? You're heating the Nest thermostats or any thermostat. Is it a fixture? Is it a chattel?
Yeah.
So it's always important to specifically write things if there's any confusion.
And when we say write things, we mean, for example, you like your chandelier and you want to bring it to your new home. You have to include that fixture's excluded. If you don't write it down, it's automatically included. And if you take it with you, you're going to be in breach of the agreement. And which means that you could be sued. There's whatever other repercussions that the buyer or the ramifications that the buyer might want to think about, how they want to proceed. That's up to them. But from a legal standpoint, you're not allowed to do that. You're in breach of contract. Shadows included. So let's say we have like a really nice lawnmower on the property. That's not going to be included unless it's included on there. Or let's say you have like really nice a lawn or patio furniture, and you think, okay, well, why would they take this with them? Because it doesn't make any sense. That has to be included. So you have to list the things that you want included that are movable, anything that's attached to the property, if you're going to include that. Now, thermostats and all that stuff, that is something that I would put in there just in case if they've got a, as you are saying,
anything there's confusion with, I think any gray area you include. I think that just to be safe, just outline everything. If there are curtains on the windows when they're doing a walkthrough, write it down, right? Just so that there is an understanding between parties. So sometimes even if you're right in a circumstance, there can still be a dispute, a costly dispute, because the other side believes that they're right, and then you have that back and forth going on. Yeah. So write it down whenever there's any confusion about something.
Then moving on to rental items. So number 6, this is something that's created some issues with both buyers and sellers, I would say. I've seen so a lot of individuals, a lot of buyers or sellers, will have either air conditioning that's rented,
water heater.
Water heater is very common. Water heater is probably the most common one, and whatever else you may have rented. Not that I've seen these, but you could have your refrigerator rented, and you want to have that with the property. Okay, sell it with the property. You have to put that in the agreement. Okay, so it has to go in section 6. If you do not, the seller will come back to you and say, the buyer will come back to you and say, and they could say, I don't want this. Okay, let's say you've got a water heater. Buyer doesn't even want to rent that water heater, but you haven't included it in there. They can come back and they say, listen, we're not assuming this water heater. you can take it out and you can pay it or whatever, right? Now here's the issue: when you are taking it out, if they say we don't want it, you're in kind of a disadvantage in negotiating kind of power. So you could, it's not like you can take it out, rip it out, and bring it with you because you're going to have an agreement with the water heater
Well,
company.
what's typically assumed is that the buyer will pay out the water heater, and the seller will pay out the water heater, and the buyer will get to keep the water heater.
Yeah.
It's just the contract, whether it's being assumed or not, that is the question. So if it's written in the agreement that you have to assume the contract, then you have to assume the contract.
Yeah.
But if you don't write it in the agreement that the buyer is assuming the contract, then as the seller, you might have to figure out, okay, how much is owed, and you have to pay that amount from the proceeds.
Yeah.
So what this is basically saying is that is the buyer paying out this, assuming this contract, or are you going to cover and pay out this contract? Either way, they're supposed to get a water heater in that building.
Yeah. So that's something that is, I've a couple times have had.
Yeah, common issue.
Yeah, it's a common issue because we didn't know there was a water heater there. Yeah, well now you have to pay it off, and there's a lot of other fees that go along with it. Sometimes like there's financing involved, there's early termination fees, there's fees to get it because sometimes it's registered on your title that needs to be taken off. So there's a lot of things that are involved where if it's rental and you assume it, even if it's on your title, because sometimes water heater companies will register it on title. Then all you have to do is you have to let the buyer say that you're assuming it, so the buyer's side should take care of it. On the other side, from the buyer's perspective now, definitely like if it's rented, you should be arguing about it. There's definitely your right is to not be paying anything off. On the other flip side, for title, sometimes when it is rented, it is on your property, you will have to postpone it. Postpone it means that if you're getting a mortgage on the property, it has to come underneath, second in line as your liability on the property. And that postponement is something that your lawyer would definitely, like when we do a title search, we let the client know that this has to be postponed. And we go automatically and start doing it because you can't take out a mortgage without doing it.
Yeah, your lawyer needs to make sure that they're postponing that security because you're getting a mortgage from a bank, and that bank will not be happy if they find out that your lawyer placed the mortgage on title and it wasn't the water heater or whatever else was not postponed.
Yeah, I mean legally they can take back their mortgage.
Yeah, and a lot of things can happen.
Whether they do that or not is up to the bank. We're not going to represent the banks here, but for the most part, they have to come in first. So HST is a huge I guess question number 7. You want to take that?
Yeah, is HST applicable is the common question that we get from both buyers and sellers. So meaning, are you going to add HST to the sale or purchase price, or is it included within that price? The question is, it depends on the property. If there is a new build, then HST is going to be added to that property. If there's substantial improvements in the house, substantial improvements is a very broadly defined term. So it doesn't mean that you maybe finished your basement, but substantial is beyond that. Then HST may be applicable. So it really depends. When it is, in most cases, it is not applicable. So the purchase price that's in the agreement, that is a purchase price being paid by the buyer, received by the seller.
Yeah. So this will always say included in. So
most times.
Yeah, harmonized sales tax will be included in the purchase price. It's not, if you're reselling your home and it's not new and it's not substantially improved, nobody's paying it, but it'll always be included in. If you have included it, if you improved it, right, then it'll be included. But here's another thing. If you are buying or if you're selling a property, let's say you have perhaps a convenience store or a dry cleaner or anything that's on the bottom, and then you have your house on the top. Now you have, it's more of what's called like a mixed use. You have commercial and you have residential. Then it's important that you agree that it's in addition to, the HST is in addition to. There's going to be an HST calculated on the commercial part of it. So if you have a convenience store or a dry cleaning business or whatever it is, and you have like your house on top, there is HST applicable on the portion of the property that's at commercial use. So that typically should be in addition to, so that nobody's paying HST. And then on the buyer's end, when a buyer is buying in those particular instances, right? Like let's say you decided that you're going to quit your job and like buy maybe a franchise or whatever, and then there's commercial property underneath, housing on the top. You're going to get an HST number, and you're not going to be submitting HST. So you're going to be HST exempt. Not exempt, but you're not exempt from submitting it. So those are both sides. So as a seller, you'd want to put in addition to. As a buyer, you have to get an HST number to make sure that you're not going to be putting forward those funds to the government as well. Those kind of situations are very nuanced. That's a commercial purchase, semi-commercial, even though you think that it's a small business and whatever. I would say contact us right away. As soon as you're thinking about it, I would contact us when you're like pretty much ready to buy. Let us know, and we can look at the property and review and see whether there's something that we can cover you on. Okay, so that's number 7. Moving on to number 8, title search. So title search is incredibly important. This is typically what decides when the legal work starts. So,
or I guess not starts, but like you mean like
you kick off like the kind of legal work.
I meant the date. So the date, the requisition date that's written there.
Yeah,
that's the deadline that the buyer's lawyer has to search title, review everything, and then requisition to the seller's lawyer all the issues that they want fixed from title.
Yeah.
So to Harris, what Harris said, it does determine when it starts, because now your lawyer has to decide when am I going to target as that date, and when am I going to review everything and get everything figured out.
Yeah. Typically, this is 2 weeks before. 2 years is an awful long time. 2 weeks before the completion date. So it's basically making sure that the seller has clear title, and the buyer's lawyer says, hey, listen, I need you to take off this mortgage or take off this or that. It's on title to make sure it's free and clear.
2 things I think when deciding the date, that date is important. Sometimes we see buyers or sellers adding a requisition date that's maybe a few days before the closing date, so 2 to 3 days. That is not enough time for the buyers and sellers lawyer to do the back and forth where they're kind of figuring out how to resolve all the issues on title. At the same time, you cannot have a requisition date that's too far in advance either. So 6 months in advance or 5 months in advance or whatever is not a good idea, because now when your lawyer is reviewing title, they're not really getting a good idea of what is on title on the closing date, although they'll be checking again on that date. Yeah. It leaves open that opportunity for that next 6 months for someone to add other issues on title, and then now you're last minute trying to scramble to fix them.
Yeah. So you need enough time to conduct a title search and rectify any issues before the closing date, but not so much time that it's redundant.
Exactly.
So yeah, incredibly important. And in addition to all of this, as a buyer though, even though your lawyer, and whenever we get in a purchase, we're doing a title search, we're making sure the seller owns everything, you will also be taking out title insurance. Title insurance is basically if there's any defects, if there's any issues with your property, title insurance covers. It's a one-time fee. If you're taking out a mortgage, I'm almost certain, like 99.9% sure you're gonna have to take out title insurance as a condition for the mortgage. Like the insurance, I would say, even if you don't have a mortgage, even people buying cash, I would always consider taking it out, because it covers a lot. Like, I understand that costs and everything are high in buying and selling, transfer costs or what, but your asset is a lot. So if you're buying something for $500,000, $1 million, title insurance, and don't quote me on this, it's basically the title insurance is anywhere between $300. We've seen it go as high as $1,500. I'd say we're averaging, I would see mostly around $500 to $600. It covers you as long as you own it. It covers any kind of fraud and forgery that gets your title changed.
Not all fraud, but most frauds.
It does cover, some of it. So it's definitely worth it, because the value of the house is so much, and it's covering all of it for the entire time, and you're paying once. So it's definitely something that even if you don't have to take it out, I personally, if I'm buying a house, I would take it out.
Yeah, one good example we've had a few times actually happen is so on closing date, the buyers and or the seller's lawyer will send a statement of adjustments to the buyer's lawyer. That statement includes everything that is owed on closing date and all of the subject to all the adjustments. So you have your purchase price, the deposit that was made, property tax that was paid by the seller, and how much was owed by the seller and how much is owed by the buyer, condo fees, etc. So when it comes to those adjustments, a good example is your property tax. Let's say that you're selling or you're buying and selling on the first day of the year, but the seller has already paid the entire year's property taxes. What happens is then you, as the buyer, have to compensate the seller for the portion of property taxes that you would have owed. This does not happen on the first day, but it's just a good example. So really, you would owe 364 days, and then the seller owes 1 day. And then you have that adjustment made on closing. Sometimes what happens is the seller may provide information that is not accurate. So the seller may say, I've paid this entire year's property taxes, give me an adjustment, and then we receive any requisite proofs, but they're not correct. Then at the end of the day, then the seller now avoids paying. So the buyer's lawyer, then your lawyer goes back to the seller's lawyer and says, hey, your client did not provide accurate information. You owe this amount in property taxes. They're unwilling to pay. What happens is then title insurance kicks in, and then they cover that cost. We've had times where there was amounts exceeding $1,500 to $2,000 in property taxes that were claimed to have been paid, but they were not. Yeah. And then title insurance ended up having to cover it.
Yeah. I mean, title insurance will chase down the seller, but point is, it's not your problem.
Yeah, exactly.
As a buyer, it's not going to be your problem. As a seller, pay your taxes. So when our sellers come in, we say you need to ensure that you're giving us accurate information because you're going to be held on online here. Let's say for sellers, you say you paid $2,000, but you really paid $1,000, and the buyers bring it to your attention, you ignore it, and then they get title insurance to claim it. Now you're going to be owing more than just the property tax because there's going to be other fees added on by the title insurance company for pursuing you. And the longer they pursue you, the more fees that there are.
Typically, they'll have their legal department issue you a letter saying that you owe us this amount, including all the legal fees, and then slowly they'll eventually perhaps even move on to small claims court if you don't pay. Yeah,
so definitely something that you can't get away with. Let's jump to title. Number 10. And I just want to briefly go over this because it's a huge, intimidating paragraph. What I want to say, which is incredibly important, we're going to talk about home conditions a little bit later on. But this is for sellers. Sometimes sellers believe, and actually it's for sellers and buyers, to be honest. Sellers believe, hey, listen, there was no home condition, and so therefore anything can happen to the house. It doesn't matter. This paragraph says that there can't be any outstanding work orders or any notices from the. Hold on, let me see what's the exact language. So there's no outstanding work order or deficiency notice. So it does not mean that you can, if there's no conditions, that anything can go. You still have responsibilities as a seller, and buyers, you still have a right. Now, it's not maybe as strong as what you would have done with a home condition, but we're going to get to that later on. I just wanted to quickly point this out, that buyers still have rights and sellers still have responsibilities, even if there's no home condition.
I think there's the, it's not directly related to this clause, perhaps. I think there's another one, maybe we passed relating to the Planning Act or zoning. So one important issue is that we faced a few times is that a seller had built maybe a shed in their backyard, and that shed was over their eligible amount of square foot where you don't need a permit. And then they tried to sell the house. They got an agreement of purchase and sale, and they still did not have a permit for that shed. Then the buyer's lawyer comes to the seller's lawyer and says that you need to have your client remove the shed or obtain a permit before the closing date. And often this is discovered late into the game. You're close to the closing date, so it's hard for you to obtain a permit in that time. So now you have to. There's a cost involved going in there, taking apart that shed and disposing of it. So that's something to keep in mind. It doesn't mean that you have to do these things. Maybe you do. Maybe you did make a shed and you didn't realize that you needed a permit. Have a discussion with the seller or the buyer as the seller. Maybe tell them, look, I have this shed. Do you want this? Maybe ideally before the agreement, let them know I didn't obtain a permit. You might need to obtain a permit for this or take it subject to the lack of permit.
So I think that's number 15, Planning Act, I'm assuming. Okay, so now let's jump to 18, adjustments. There's a lot of questions in and around this, and you touched upon this.
I did.
Why don't you just take it off then?
Yeah, so what I was mentioning earlier with the statement of adjustments. So on closing, you're looking at what the buyer owes and what the seller owes for certain costs related to the house or the property. A good example is the property tax. How much do you owe? How much does the other side owe? And how much has been paid? So how do we calculate the exact amount? Other things to consider are your condo fees. Same thing happens. How many days into the month are we? Has the seller paid? Should there be an adjustment? Yeah. What are other adjustments?
I mean, if there's heat, if you put that into the agreement, if you're like you're using your heats off of oil or anything like that. There's
the tanks.
The tanks. Yeah. So and if there's a propane tank, whatever it is, sometimes you throw in septic, but that's not often. That's more septic is probably just a condition in there that says that the seller will empty it out before they leave. But for the most part, it is heating, oil, tanks, propane, stuff like that. What happens is nobody's going to go around and say, okay, well, you paid this much and now like you're not going to send 2 checks to the city for property tax or ask for a refund. You adjust it into the purchase price. So that's incredibly important because a lot of times the buyers are going to come in and be like, why am I paying more? Well, you're paying more because the seller paid more property tax than their share. And so instead of the seller going to the city and asking for a refund, because the city's not going to be giving any refunds, it's because what's going to happen is you're going to adjust it to the purchase price. So let's say the seller paid an extra $1,000 in property tax. Your purchase price essentially is adjusted up $1,000. It's not that you're paying more for the purchase price. Purchase price, if you let's say you agreed for $500,000, it's still $500,000. But then you're going to get an adjustment for $1,000 that says this is for the property tax. Maybe you'll get an adjustment for $50 for the condo fee. Whatever it is, it's adjusted. On the other hand, let's say the seller didn't pay their share and they paid $1,000 less than their share. That's going to be deducted from the purchase price. So if it's $500,000, it's going to be $499,000. As a buyer, you're not getting any kind of percentage off. You still have to pay the city. You're going to have to pay the city $1,000. The buyer is no longer responsible. You are responsible to pay that money because it's been adjusted. But the point that I'm trying to make, or we're trying to make here, is that it is put into the purchase price and it's adjusted there.
That's a good example as well. When you have the seller didn't pay yet. I think also when you have, this is for very unique situations, when you have distressed properties where the owner wasn't able to cover their mortgage and their costs, and maybe you have a foreclosure sales, things along that nature, it's sometimes better to get a tax certificate from the seller so that you know that, okay, taxes are up to date, and I know what has and has not been paid. Because in those circumstances, you know they're behind, and then there's a higher risk involved because it's not a typical situation. So there is that kind of a situation where you might have to take an extra step.
Definitely. So we've done adjustments. Now I want to go through signing. I want to jump to Section 28.
We go back 22.
22.
For sellers, that's probably important. Family Law Act.
Yeah, I was going to just include that in. 28? So let's do 22 and 28 together. So I wanted,
okay. Yeah.
So 28 is basically signing off and agreeing to the agreement. So you are initialing every page and then you're signing off on 28, right? So for the first part, the successors and assigns, that is the individuals on title. Also, who's initialing? The individuals on title. So what Omar was getting at in terms of Section 22, which is the Family Law Act, is referring to the spousal consent. This is incredibly important. People do not understand this enough, and so I want to really kind of hammer it in. Both buyer and seller. This is important for both buyer and seller. If you're living in a marital home, okay, and this is only applies to marital homes, and your wife is not on title, or your husband is not on title, you're the only one who's on title because for whatever reason, maybe you felt like your credit was stronger. I don't know, whatever financial reasons, whatever life reasons you may have, but it's a marital home. They still need to sign the contract, okay, because they have rights vested in the property through the Family Law Act, potential rights. So for that reason, they need to agree to the disposition of the asset or the sale of the house. That typically boils down to just signing on the spousal consent. They're not necessarily initialing the pages. They're only signing on the spousal consent, and they're dating. And this is only if they are not on title. So that's something that's incredibly important.
And one thing to remember is that if, let's say, only one spouse is on title, and then you sign an agreement with the seller, with a buyer, it does not mean that you can get out of that agreement just because your spouse did not provide consent. That can actually put you in a very tricky situation because in Clause 25, it states that you're telling the buyer that I've provided any spousal consent that was necessary, and the buyer is relying on that information. So that can get into very litigious territory when that happens.
What clause? I think clause 22. Did you say 25?
22, I meant 22, yeah. Where it says seller warrants that spousal consent is not necessary.
Yeah, so, and for buyers, that's also important because now you have another individual that has interest in the property, and there's more of a fraudulent sale, arguably, that was made. So that's something that, as a buyer, typically you don't say, hey, listen, let me see if this is a spousal property. And if you're married, you're really relying on the sellers. That's your reliance is there. But for a seller, it's incredibly important. So that kind of is the end of what's the template format. And then you normally have a Schedule A. Schedule A is like page 9 of the PDF that we have on here. This is where you typically customize the agreement. And this is where you can put in your conditions. And so typically you can put in a lot of stuff, but for the sake of time, and I think we're pushing.
Getting long.
Yeah, this is getting long. So I want to quickly cover 2 conditions: financing condition and home inspection condition. Okay. Why they're important, why you need to put them in there, and why I would argue why I would advise to be patient in buying a home and including those conditions in the agreement, as opposed to kind of getting rid of it just to get a house. Okay.
First, before we jump into it quickly, what is a condition? A condition is basically the buyer or seller saying that this agreement, we're offering this agreement, but it is subject to this condition. So if the other side accepts it, then now that condition has to be fulfilled by the person that has the ability to fulfill it. And then if they do that, if they waive it, they say, I've completed this condition, then the agreement becomes firm. So it's kind of like you have a conditional offer, and then once that conditional conditions completed, now you have a completed firm agreement of purchase and sale.
Yeah. So a good example, just to put context to all of that, is a financing condition. Typically, you'll put in a financing condition, or buyers will saying, hey, I want to buy your house for this price, these terms, but it is conditional upon me being able to arrange financing on the house in the next 5 business days, and if I do, then I will waive it. So then the buyer will typically give another either amendments to the agreement or waive a fulfillment of the conditions. There's a few ways where you can get rid of the condition, and you'd get rid of it before the end of the 5 business days.
So what that means is, so within that time frame, by the 5th business day, you have to sign this other document and give it to the other side, and then that means that you waive the condition, and now it's a firm agreement. if you don't want to waive it and you decide I don't want this property, if that time period passes, then it's been canceled. The agreement is no longer valid, but you still need to sign some documents to kind of release the deposit and get everything.
Like
else
it's a mutual release, but the buyer is entitled to their funds back. So that's what you would proceed, and typically you wouldn't just like you'd let the seller know, hey, listen, there's no financing. Now, why is this important? Not only for the buyer to have, why I would argue it's not bad for sellers to have either. Okay, and I'll explain why. From the buyer's perspective, right? When people go in and they say I have a pre-approval, that pre-approval is more like a very high level bank, like at the bank saying, okay, well, I've looked you up and it seems like you're all right. And provided that everything you say is true in all these other documents, and your debt ratios and everything is exactly what you said, we'll give you this money. So they've essentially given you like the green light to say that your credit's fine. That doesn't really mean anything because the bank will always look at the property. Will always look at the property. So they'll have an appraisal done for the property to make sure that the property is worth whatever price it's at and whatever is between you and the bank. They're going to make sure that all of that checks out. If it does not, they may not extend a loan, even though you've been gotten pre-approved. You've been pre-approved. So that is incredibly important to think about because you may be confident going in, and now all of a sudden the bank says no. You're going to be looking at every avenue, or otherwise you're in breach of contract. And you're going to be looking at like, why am I in the situation when you don't have to be, right? So that's why I'm saying it's incredibly important to say, hey, I need a financing condition to make sure that I can buy this house. If you're getting into, for example, we've seen individuals who were not approved at a bank for one reason or another, where they went in firm, now they have to buy the house. They're looking at private money. Private lenders are incredibly expensive. Incredibly expensive. So that's something that definitely needs to be considered. Now, as a seller, the reason why I say it is incredibly important, again, there are two outcomes or situations where you're in. You're either in an up market, I would say, right? Or, three you could say, but like you're in an up market, the market's stable, or home prices are going down, okay? So if home prices are going down, I haven't really seen that, so I'm not really going to be speaking to that. Let's just say it's a stable market. We'll talk about that, and prices going up. Prices going up is what we're seeing pretty much all the time, right? A buyer or a seller may say, okay, well, you know what? I want firm. They better give me this, or else I'm going somewhere else. Like I'm just going to sell it to somebody else. And if they don't give me that money, I could get to keep their deposit. Okay. It's not that easy. Deposits, like if you want to keep the deposit, the buyer does have recourse. They could sue you for that deposit back and see what you lost in commissions and all of that, or your resources and fees for that breach of that contract. What was that loss? You don't get compensated for the sake of entering into an agreement. It is based off of what you lost. Now, let's say you're like, all right, you know what? I sold this house to person A for $500,000. Took $10,000 from them as a deposit. They were not able to buy the house from me, so I sold it to person B for $600,000, and I kept the $10,000. I got $610,000. That's not going to happen. The first buyer can sue you for that deposit and get it back. It's not that you're just going to keep it. There's a breach of an agreement there. Yes. What did you lose? You didn't actually lose anything. You gained from it. Your price went up, so you did not lose. So you will have to give that back. And depending on how agreeable you are and how the process goes, the buyer may add their own attorney's fees as well for suing you, right? So it's not that that's not going to help you out, okay? So it's better if you think that you're doing this just to keep the deposit, let the buyer get approved. If it's a stable market, okay, which means that maybe there's not a lot of contracts coming in, then you have, do you really want to go in and resell the house for the same purchase price that you sold to this person. And yeah, you could keep some of the deposit, but the headache and the stress of trying to find another buyer is annoying. So it's better to keep and make sure that the buyer who wants to buy property can buy your property. And so it may be advantageous to give them that financing condition. And next one is prices going down. Okay, if the prices are going down and somebody gives you a $10,000 deposit and then they default on it, okay, well, let's say your house was worth $500,000 and then it goes down to $400,000. And yeah, sure, the other person does owe you money, the original buyer, but are you going to spend the time and the resources to chase after them and sue them to get that money when they may not have those funds available? It may just be better, especially in a market that's going down, just to sell the house as soon as possible, because each day the price is going down, as soon as possible to a person with funds. So again, I'm not saying this is the right answer for everybody. I'm saying I encourage this to all of my buyers and sellers. Okay, it is naive to think that, okay, well, when it's firm, it's firm. Okay, that's it, it's done. No, you want something that's firm, but there's the buyer has the funds to hold down the purchase.
I think in the current market also you see a lot less pre-approvals because banks are just inundated with mortgage applications. So they're prioritizing that person that's found a house, has a firm agreement, and is looking for a firm commitment. So from a buyer's and a seller's perspective, you have people that are looking for houses that don't have a pre-approval, and they have to go through a longer process before they can get that approval. At least that's the common situation in the current market. So it becomes even more important for you to have that condition there for them to go through that process of getting that approval.
Yeah. So I would say, again, I want to hammer it home. Financing conditions are important. Now, home inspection condition, you want to take that?
Sure, I can talk about it a little bit. A home inspection condition is basically the opportunity for you to go and look at the house, and inspect the house. Ideally, hire an inspector who will walk through the house, give you a report. It's important if you do take this, add this condition, to get an inspector that has good experience. Ideally, someone who understands the different aspects of inspecting a house, because there's so much involved, from roofing to electrical to plumbing. It's hard for someone to be an expert in everything. So someone that has at least the experience to be able to kind of point out the key issues in all those areas is very important. Whether you should add an inspection condition, that's a different question in today's market. I think it really depends on the property. Most people don't add conditions. What do you think, Harris?
So I think most people don't, and the reason why I argue you should is as a buyer. All right. So whereas the financing condition, I felt it was advantageous for both. As a buyer and seller, I would say, I guess it leans one way, right? From a buyer's perspective, you want to see the house and make sure that it's fine. If you come in afterwards and the basement is flooded, it isn't like it's going to be something that you're going to want, like you want to pay for it. It's going to be expensive, but it's not something that you can go back to the seller and be like, hey, listen, like you need to refund me or whatever, give me some money for this. That's not going to happen, right?
Usually that ends up in a lawsuit. Both sides go to court, spends tons of money, and then
if it's in the agreement though, in the agreement that they made a representation. If they haven't made a representation, right? If there's no home inspection done and nobody's seen anything, then like it doesn't really matter, right? Mm-hmm. Therefore, for the buyers, like the sellers, it's like, all right, I don't want a home inspection because I don't want issues coming up. Issues always do come up, to be honest. Mm-hmm. And as a seller, I would, if somebody does give you a home inspection, I would not say, okay, well, hey, listen, there's all these things wrong with it, and you say, okay, fine, I'll fix everything. You can have a discussion, be like, no, I'm not fixing half of this stuff, and this one I will, or this I won't. So you have a conversation. That's perfectly fine. From a seller's perspective, again, I can understand how you may not want to have the home inspection done. From the buyer's side, though, definitely it's something where you're looking at stuff and you're saying, okay, well, needs to be fixed, and you don't want to be paying for things afterwards. Now, there's a few things here. Home inspection condition does not mean that now everything, like you've looked at the house and like there's a warranty placed by the seller that everything's going to be good. That's not what it means. The point of a home inspection is look at the house. Is it all right? If it's all right, that's good. If it's not, bring it up and negotiate with the seller in terms of price and who's going to fix it at that point. If you don't bring it up, there's no going back to it, right? And that, again, for sellers, if there's a home inspection, you're not obligated to do anything after if the buyer doesn't bring anything up. At the same time, if the seller is actively hiding something, okay? So if, like, for example, there's a home inspection condition, the seller actively knows that, for example, their basement is leaking and they're trying to figure ways out to hide it, even if the buyer does not find out, doesn't negotiate it, if there's proof that you've actively hidden this defect, you're still responsible for it. So that's the only thing.
And I think that's where conversations usually lead when there's an argument, where the buyer might claim you actively hid this. The seller will say, no, I had no idea this happened. And then there's a dispute, and then that's what leads to court and all the fees, and you're in a bigger headache than before. Yeah. So it's always better to get these issues looked after as early as possible.
Yeah.
Get an inspection, discuss it with the seller, or the seller discuss it with the buyer, and be as transparent as possible, because in the long run, it's more costly if you don't.
Yeah, and that's I think that wraps up our podcast or our show here. It's an hour long. I know this has been a long kind of talk. Firstly, prepare yourself so that you're not facing anything unexpected. Secondly, I would say that a lot of this stuff, you should be having strong professionals around you to guide you through everything. We see this kind of issues all day long. We know how to handle them. If you want to reach out to Treadstone, if you're buying, selling, refinancing a home, I would urge you to reach out to Treadstone Law. I think I will try to put our contact information below for the firm. Send us in it's never too early to contact us. If you are buying a house, if you have a purchase and sale agreement, it doesn't matter if that agreement is going to be closing 6 months down the line. Send us that agreement. We could start looking at it. We could start looking at the title search. We could do a lot of things and show you basically what your next steps are.
And in addition, also, we do have a number of other podcasts. We've been doing a series on real estate over the past few episodes, and we're going to be keep going on with different topics. We did an episode on buying or selling real estate, whether it's the right time. We're doing another episode on whether you should break your mortgage commitment. And what else was there? There's
how to pick a lawyer, legal fees, all of that stuff. That's incredibly important. So we're kind of going through the most important questions that people have, topics, and kind of discussing it so you're prepared for your next buy, sell, or refinance.
Yeah, and in addition to that, just before we go, one last thing. We also do have real estate webinars that we run live webinars on the purchase, sale, and refinance process. So we just really, it's an opportunity for you to understand the entire process from a high level, understand each of the participants, the people that will be helping you, what their role is, what you should expect from them, and most importantly, what is expected from you. It's really a chance for you to understand what the common mistakes are in the process and different things that you should be doing in each step of the process that will ultimately end with less stress and then less mistakes, and then obviously then at the end saving money as well.
Yeah, I definitely recommend the webinars. Webinars will give you right today we talked about the agreement of purchase sale, and that's one aspect of a lot of things that go down when you're buying, selling, or refinancing. Our webinars are designed to kind of give you an understanding of all the different important areas that you need to really focus in on in a way where it's digestible. Our webinars are hosted by yours truly, 45 minutes to an hour long. Definitely worth it. Definitely worth it.
I guess that's it. That covers the podcast.
Yeah. All right. Take care, guys.
Take care.